respect people's time, those who have joined us today. So great. As I told Lane, I'm here, but Chapter 111 is not the area in which I focus. So I am going to rely on everybody to help sort that out. I won't be able to provide as much thoughtful commentary as Lane usually does, but I do kind of know where we are in all of that. And I'm going to be taking minutes, or not minutes, but notes as I always do. So Sandy's going to help kind of keep track of who is ready to speak. Before we do that, let's look at the remote attestation draft. It was recirculated today. Thanks to Lorianne for getting that out to us with the changes. I still need to adjust the report to reflect the change that the Law Commission made. We presented to the Law Commission at their meeting, explained why this was necessary, explained why wills are not included, and they approved, as Sandy said, approved this proposal to go into a bill if there is an emergency session and if the legislative the Judiciary Committee, which is looking at it, decides to include it in the bill. Things are still a bit uncertain about all of that. The Judiciary Committee did hear testimony on remote notarization. That is included in the bill that's going forward if there is an emergency session. And unfortunately, because of a very tight schedule, although Lane was queued up to testify about remote attestation, they ran out of time, and that was unfortunate. So I'm not quite sure what's going to happen with this, and as soon as we, Sandy, or any of the rest of us hear anything, we can share with each other. But it's at least, I think, a really good, strong proposal, and the Oregon Law Commission agreed that it's thoughtfully done and worth considering in the regular session if it doesn't go through in the emergency session. So we can feel good about that. The one thing they were concerned about, someone asked a question about whether electronic presence could mean that somebody could be talking to someone on the phone and that would be sufficient. I personally don't think that would be considered to be to the same extent as if the individuals were physically present, but they wanted to make sure that the people who were electronically present could both hear and see each other. And so that's the reason for the addition that you saw in the revised bill or revised proposal that was sent around, just adding the words by sight and sound. And that indicates that the people, it still says to the same extent as if the individuals were physically present, but they have to be able to communicate by sight and sound. That may, the concern a little bit is that may restrict people who have issues with sight. Certainly a testator could execute, a testator who is blind could execute a will. I don't think under current law, a non-sighted person could serve as a witness even if the person were physically present. I'm not sure about that, but the idea was that it should be the same as it would be if the people were physically present. The thought was for electronic presence, they wanted to clarify that people should be able both to see each other and hear each other. So that's the reason for the addition. And with that addition, they approved it to go forward. We could come back to them if we're concerned about that, but otherwise it just moves forward like that. So comments, concerns, anybody want to add anything?
Well, this is Gretchen, and as I talked to our commissioner for the blind, the director of the commission, most of people who are legally blind still have some vision, and so there is some ability of them to see, and they don't have a problem with the word of by sight because they use it themselves. You see, that's language that they use as well. And so I don't think that there would be concern from the Commission for the Blind on that.
That's really good to hear, because that was my one concern about how this would read.
Yeah, I don't think it's really going to affect the majority of people who are sight impaired.
Right. That's great. Anybody else? Good. Okay. Well,
just one comment, just to back up what you said about the progress of the bill. The commission knew everything about the status of the bill when they voted on it, and the thought was that we now have it as an approved law commission bill. So at any time it does become available, whether it be during a special session or during the 21 session, we have it to bring up. The commission will keep track of everything that's going on, and I'll continue to update back to this group when I have anything about the legislative progress. But thank you all for the work on that bill. And I think we're in good shape. Back to you, Susan.
That's great. Okay. So I'm going to close that one and hope that, I think I just closed. No, I didn't. I don't print much, so everything's on screen. Okay, so now let's turn to chapter 111. And the version that Sandy sent out has the changes that we talked about at our last meeting. Thank you, Lorianne, who is always on top of all of this. So I think we could start with the beginning, look at what we did before, not spend a lot of time rehashing what we did before unless there is a reason now that we see it in print to revisit it, because we still have a number of sections that we didn't get to. And I'm hoping, I reviewed my notes, I'm hoping I remember kind of where we were in doing this, but some others of you can help guide us if that becomes necessary. So in section 2, we were trying to figure out when the ORCP would apply, and added where court issues a show cause order. We spent a lot of time last time talking about that, and this is where we ended up. So are there any questions at this point on section 2?
So if I can just make a brief report. So it was delegated to me and Brooks Cooper to go ahead and take a look at this and see if we could rework it in a way that made it clearer to address concerns that were raised by Judge Burton and some other judges, that, among other things, the court never becomes a party to these things, including a party from whom a person who is subject to a show cause issued by the court can seek discovery from the court, et cetera, et cetera. Brooks and I have met a couple of times virtually and have reworked section 2 in a way that we hope would make it clear sort of when we are ejected into the ORCP sandbox, and then conversely, when having been put in the sandbox, how we emerge from the sandbox so that the ordinary probate procedures and local processes of a local court or a given probate judge become the controlling procedure. What we agreed to do is to push that back to Heather Gilmore and Jennifer Todd, who did the original draft of section 2, for their comments. We have not yet done that. As you may know, Brooks is heavily involved in the Antifa movement and has been marching every night. And so that's sort of taken us, that sort of delayed us, but we'll be circulating that to Jennifer, and wow, just no reaction from anybody. None. And we'll be circulating that to Jennifer and Heather in the next.
We're all trying to figure out whether you're serious or not, and nobody wants to step in the middle of it.
I would have thought I would have had something from John. Really?
No, I'm sort of like, resting my eyes here.
My bangs cover up my forehead that was like, huh?
Yeah, and so we have been working on that portion that's been delegated to us. It needs to be workshopped a little more with Heather and Jennifer, and that's where we're at.
Great. All right, we will look forward to seeing that once the four of you now get together and you get Brooks off the streets.
This is Lorianne. Matt, would you be able to include me on those conversations just so that I can see what's happening and be able to comment in real time rather than waiting until the whole group gets it?
Absolutely, Lorianne. Yes.
Thank you.
Even better, yeah. Thank you. Okay, so that's section 2. All right. Section 3 is what used to be section 5, if I'm tracking this correctly, and it has to do with representation. So it was moved, which is why the whole thing appears as green. But what we talked about last time was the court's ability to appoint a special representative and how that would kind of play into this. We did spend a lot of time talking about this last time, but my notes were not entirely clear about where we ended up and whether there was more to discuss in connection with that as not. One of the things that I noticed in reviewing this again, and I don't think we talked about, is a question, and maybe this actually goes down to the next section about notice, but relates to the representation that Lorianne had asked whether a special representative is treated the same as a guardian ad litem for purposes of notice. And I don't think we had talked about that. That may be more when we get to the subsequent section, but wanted to not miss that over in the comments. So section 3, current section 3, which is representation by fiduciaries and parents, comments on that.
So this is Lorianne, and I just want to inject that we actually stopped on section 5. We didn't finish going through it, which is now section 3. So if that helps for the conversation.
Thank you. That's what it looked like from my notes, but then I thought maybe I had missed something. My notes weren't entirely clear. Thank you. Thank you.
No, Susan, that's Lorianne and Susan, correct.
This is Judge Cobb, and my question is under section 3 is basically the language, the standard appears to be there's no conflict of interest. So at some point, should there be a standard that it is in the best interests of the minor or financially incapable person? And I'm specifically thinking about for example, a non-custodial parent or a parent who maybe, proving a conflict of interest, I think could be difficult. For example, if you had a parent who sees the inheritance or the recovery of the child as a gold mine and wants to have the child buy him a new house and buy him the, Escalade and pay for their schooling, et cetera, does that become a conflict? And can that, it seems that it would give everyone some clarity if you could establish it's in the best interests of the person, the minor or financially incapable person.
Well, this is Jennifer, and Judge Cobb, just so that I understand, are you saying that the court would make a finding that it's appropriate for the parent to represent the minor, or is that what you're asking?
Well, I don't know that the court has to, but I'm wondering if there has to be an allegation that when you're stating this in the pleadings, that you're making the allegation this is in fact in the best interest and there's no conflict, because that would then allow, for example, the custodial grandparent that the drug addicted parents maybe they don't have a conflict, but are they really the ones that should be binding the child?
Well, so I guess the way that I would think that this would happen is, you know, we have to, so let's say it's a petition to open a probate and there's a minor who is an intestate heir. You would have to identify in that petition who would be the person who would receive the notice, and presumably it would only be a parent. And then, so in the petition, I suppose the personal representative, if they had adequate knowledge, could make the representation. There appears to be no conflict of interest for mother to represent minor child. But I would think there would have to be some sort of allegation of that sort in order to enable the person identified to appropriately receive notice.
And
Heather, do you have any thoughts about that?
Well, I have two thoughts. First, on the issue, we can't draft the statute to address everyone like their parents are drug addicted. We have to be balanced and fair, because not every child has a parent who's drug addicted, or parents who hate each other, or parents who will exploit them. So we have to have some balance to the statute. And the way that we have balance is we describe that, you know, this is who can do it. Now, in a lot of cases, the mom or the dad is perfectly appropriate, but in a lot of cases they aren't. So how do we describe? Well, conflict of interest, just kind of leading that sit there, gives the judge discretion. But in whatever document that you petition to be appointed, then in that document you would say affirmatively there's no conflict of interest.
But I guess my question is the conflict of interest the appropriate standard? Or, for example, in Chapter 125, the overriding requirement is it's in the best interests of the respondent or protected person. So is that the allegation? And if you've got, you know, perfectly fine mom and dad, sure, you can say it's in the best interests to have mom and dad. If you've got somebody embroiled in a caustic divorce, I don't know, maybe it's somebody else.
Well, and this is Jennifer, and the other part of this is, if you think about it from the lawyer representing the personal representative who just wants to get the probate open and move it along, I don't really want my client, the personal representative, making guarantees to the court about the adequacy of some representative that my client may or may not be able to make that judgment. And so then are we at the position of then, okay, now somebody has to petition for a guardian ad litem? I mean, or a special representative?
But wouldn't that be appropriate if the personal representative doesn't know? Then wouldn't it be appropriate at that point to ask for a special representative and have the personal representative's backside covered at that point?
Yeah, this is Judge Burton. I think it's problematic for the PR to say, I don't know who these people are, but we're just going to send notice to them. I mean, I don't think that complies with the PR's fiduciary duty to make sure that everybody gets notice.
Well, right now, nothing happens. We all need to acknowledge what is the current state. There's no obligation, nothing, the big fat zero. So I'm looking at Section 3, where a parent can represent and bind the parent's minor or unborn child if a special representative or fiduciary has not been appointed. So I think right now, Section 3, paren 4 is the default that's happening in reality. So that's Section 3, subsection 4 on page 1. So then when we go over to Section 4, what we're talking about is when we're not using a parent, right?
This is Judge Cobb. I'm back up on representative by fiduciaries and parents to the extent there's no conflict of interest.
Right.
The green part on page 1.
Mine's not green, but I see page 1, section 3, to the extent there's no conflict of interest, subparen 4, a parent may represent and bind a parent's minor or unborn child if a special rep or other fiduciary has not been appointed, conservator. Then we go down to 4, which is the provisions for the special rep. So the issue is, for you, Judge Cobb, you're saying, should the standard be no conflict of interest or should it be best interest? Is that what you're asking?
Yes. Because my question is, how are you going to, even the attorney for the PR, how are you going to establish no conflict of interest with, you know, if you don't personally know that, you know, do you have to do a drug test for mom and dad? Do you have to look at their credit rating? Do you have to, because it seems
those
to me—
aren't conflict of interest issues, Your Honor. Those are different than conflict of interest issues. They're the most appropriate person issues versus conflict of interest issues.
Right. So how are you going, which should be the standard to bind the minor child? Is simply a no conflict of interest? It seems to me it should be in the best interest.
Yeah, I think that it should be no conflict of interest. And the reason I think that it should be no conflict of interest is because making a best interest of the child representation is really hard to do as a practical matter. I mean, you can be the most responsible PR. You can call, you can talk to the mom. She can sound 100% reasonable. She can be totally, I mean, we don't have the ability to just do a credit check on somebody without them signing a bunch of papers and paying the credit check fee. So as a practical matter, on the ground lawyers trying to do the best interest, I'm not sure that that's all that practical.
Matt, can I chime in? This is John. I couldn't help reading ahead, and I noticed that in section 4, a special representative or a guardian ad litem is appointed when a party or the court determines that the representation is going to be inadequate. It does not mention a conflict of interest. It looks to inadequacy of the representation. So you have a problem in the difference between 3 and 4. If the representation is adequate, you cannot appoint a special representative, but the parent under 3, as it's written, cannot act if there's a conflict of interest. So obviously the conflict of interest may not be sufficient to cause the representation to be inadequate, and now you have a dead end. I don't think conflict of interest should have anything to do with any of this. I think you should just rely on section 4 and the circumstances upon which you decide it's appropriate to have a special representative or guardian ad litem. And until you have one of those, the parent ought to be able to represent the child. And that would be really clear and really simple.
So what should section 3 say, John?
I'd take out the conflict of interest altogether because it's just troublesome.
So it would just be a blanket, a parent shall represent and bind a minor child unless a special rep, conservator, or other fiduciary? I
think what you have in 4 is fine. In 3 sub 4, that's fine. I'd cross out the conflict unless there's a conflict of interest provision. But my larger concern with this section is the trust. It's nonsense to talk about a trustee representing and binding the beneficiaries of the trust. In a probate proceeding where the estate passes to a trust, the trustee is the beneficiary. The trustee is not representing the beneficiaries of the trust. The trustee is the beneficiary. So it's it's kind of nonsense to talk about representing the beneficiaries of the estate, because especially when you have this conflict of interest overlay, you always have conflicts of interest in trusts. The trust code says you can be a trustee even if you do have a conflict of interest.
So let's go back to where we are though, because we're on section 3 and you're saying take out in section 3 on page 1, take out the partial phrase that says, to the extent there is no conflict of interest between the representative and the person represented. Take out that
I
whole.
would take out the conflict of interest. I think it's just troublesome to have that, and it's injecting a totally new element into all this stuff that doesn't exist now, and I don't think it should.
Doesn't this,
I want to
doesn't this come right
ask
out of 130?
I want
Hold
to
on,
ask a
Susan first.
I want to ask a clarification. And again, this is part of my just not understanding how all this works, but maybe this will help us figure some of this out. My notes from last time, one of the things we were talking about on what is now section 3 was whether it should be here at all, the whole section. And that relates to my question is, what is the purpose here? Is this just with respect to notice in connection with the, because when we get down to section 4, representation, it's talking about notice in connection with this, or is this section 3 representation more than that? What are we trying to accomplish, and do we need the pieces of it, all of the pieces of it, like the trust piece?
Well, so this is Jennifer. I think so first of all, the context of this is that this representative section was based on what's in the Uniform Trust Code. And I agree with what John says about the trustee part not being necessary. That's from the Uniform Trust Code. That doesn't really apply here because a trustee is a beneficiary. So that easily could just come out unless there's some other reason it should be in there that I'm not thinking of. But you know, this is a problem when you have an estate and you either have an intestate estate where there's a minor child, or you have a will where the person made their own will and they left something to a minor child or something, and you want to have a consent on a verified statement, or really to have a person receive effective notice, it needs to go to an adult. And so that's the whole purpose behind this. And like what Heather said, there really isn't clarity on how to do this. And so you'll give notice to the parent or whatever, but that's not clearly based in the statute. And so that's the purpose of section 3, is to provide a practical way of people who aren't legally able to receive notice by some responsible person. And the other thing I want to point out for the judge's benefit is, just because this person has received notice doesn't mean that they are going to be the person who's in charge of the money that the minor or the incapacitated person receives. So if a parent gets notice on behalf of this, the court still has the ability to say, okay, 10-year-old Johnny's share is not going to go into a conservatorship or a custodialship where mom is the custodian. His $150,000 is going to go into a conservatorship. I mean, the court has the ability to govern who gets the funds and how they're spent. But this is simply at this initial get-go, who gets notice.
So Jennifer, we changed section 3 to take out the language, to the extent there's no conflict of interest. Then down in section 4, in sub 1, we could add, on the motion of any party or a court's own motion, if the court determines that it's in the best interests of a party, the court may appoint one of the following. And that way we take out all the references to the conflict of interest, and we use the best interest standard so that the court can do it whenever the court thinks it's appropriate, or any person who's interested in the well-being of the minor or other party.
So Jennifer, this is Judge Cobb. Under I'm confused now because under sub 4, a parent may represent and bind a parent's minor or unborn child language. And you're saying that the parent should be able to sign the verified statement, which would give the $150,000 to, I don't know, put them under the jurisdiction of the authority of the parent. But this is not just referring to notice. This is representing and binding the minor or unborn child. Represent and bind is, I think, is far beyond having the right to receive notice.
Well, I kind of go ahead, Jeff.
No, I'm just asking for clarification because I'm confused.
Well, and you're correct, Judge Cobb. I agree with what you're saying. It does allow, so it would allow the parent to consent to the verified statement, and then the child would receive the information to heirs and devotees telling them they have the 4 months in which to file a will contest or whatever, and they would be, if the parent received that and took no action, the child would be bound by the inaction of the parent in doing that. But again, that doesn't mean that the parent is the one who receives the funds. And so if it's $150,000 and by the time they're ready to close the estate, and the probate lawyer says, the court is not going to want mom to be the one who is going to manage this $150,000, or the court is going to require a conservatorship, then at that point, I would say you no longer have Section 4 apply, because now you have a conservator who is appointed for the child, who's going to receive the funds, and then the conservator is the one who signs off on the consent to the verified statement.
Rick, did you want to chime in?
Yeah, I'm sorry. I missed the last 2 sessions, and I apologize for that. So I may be a little bit lost here. But what I'm reading here is it says, and of course I'm looking at it from the perspective of a creditor, it says a personal representative of the decedent's estate may represent and bind persons interested in the estate. It doesn't say what they may represent or bind them. I mean, it seems to suggest that they can act on my behalf as a creditor in any and all regards. What limits their power?
I think if I am reading this correctly, it would be the personal representative, not of the estate now being opened, but if one of the beneficiaries of the estate has died, it would be that other estate. But I'm wondering if, and I know some of this came from the trust code, whether what we're really focusing on is sub 4. I wonder if we need subs 1, 2, and 3. I'm beginning to get a little better idea of what we're trying to accomplish, but I'm afraid I'm still not entirely sure. Maybe we don't need subs 1, 2, and 3, and we're really focusing on trying to get some help. As Jennifer said, in a situation where there are minor children, we want things to be able to move forward. And maybe there's a way to do that, but
Just not minor children, though, Professor. We are looking for clear, I agree with John, the trustee is the beneficiary. Rick, I get your point, but at the end of the day, the personal representative of the third estate has got fiduciary duties in that estate. So you've got some benefit there. We're just looking for clear statutory authority that these people who we already treat as the recipients of the notice, now we have clear statutory authority for it. I think the only issue really is the parent. And John, I get your point. I totally get your point on the trustee. But how many times have you seen Warren Darris's argument about the trustee has that transparency duty and should notice the beneficiaries immediately of the underlying estate proceedings?
And every time he says that, I respond that it's bull.
I know, but I mean, he's not the only lawyer who thinks that.
Well, I know, because they're all kind of accustomed to dealing with little mom and pop estates, and and it's always easy to say, well, you should always notice everybody so you get all the conflicts out in the open at the earliest opportunity. But I deal with complex estates. I deal with situations where trying to inject the beneficiaries of a trust into a proceeding would create mayhem.
I don't disagree, but this just makes it clear that the trustee is the only party, and that's why I think it has value.
Real quick, did you want to chime in? I saw you were going to speak.
Well, okay, a couple of quick points. With respect to synthesizing John's criticism of a trustee may represent and bind the beneficiaries of the trust. This happens once in a while. John is of course right. And likewise, subsection 3, with respect to a personal representative, the exact same logic applies if we're talking about the personal representative of a third-party estate where a beneficiary has died. Again, that personal representative has his or her own fiduciary duties to those beneficiaries and creditors. And I believe that the goal of the representation provisions that we're talking about is to let the fiduciary, the personal representatives and the court know when they may safely rely on default provisions. In other words, have I given notice to the people that I need to give notice to without having to go down that rabbit hole of having to actually investigate whether or not the representation by parents is appropriate. In other words, the PR should be able to rely, absent specific knowledge or absent the appointment of a special representative, on the idea that if I have a minor beneficiary, I can go ahead and give notice to the parent without doing independent investigation. So I think that in that respect, the idea of getting rid of the no conflict of interest language at the beginning of section 3 on page 1, I think that might be a mistake, because I think that if the personal representative is aware of a conflict, that's when you have to bring that issue to a head and make sure that the representation is in fact adequate. I think that you can get rid of subsection 2, as John suggested. I think you can get rid of subsection 3, or maybe simply clarify that, because people will be sloppy about reading this and say, oh, I'm the personal representative, I can bind the beneficiaries and creditors of the very estate that I'm administering, unless you clarify. But I don't.
Oh, yeah, I think that's particularly. I'm sorry.
You're going.
I think.
Go ahead, Rick.
I don't see where it says any. I don't see anything where it talks about notice. It just says to a particular question or dispute.
Right.
Hey, Rick, I think you're right, but I think you're taking it out of context.
Okay, what brings it into context?
Well, because it's in the context of the pending proceeding. It's not in the context of the probate that the personal representative is the personal representative of. You got two probates here. You got one that pours into another one, and the trustee of the second one, or the PR of the second one, can act in the first one, but can't bind the creditors of the second probate. I think that's kind of the context of it. But Matt, the problem, I disagree with you about the probate. I still don't think conflict of interest makes any sense there. Because you always have those. But trying to bring those people trying to bring the beneficiaries of the second probate into the administration of the first probate is just going to risk creating a mess, especially when they all disagree. You're taking away the authority of the personal representative. The reason you have this provision in the trust code is because the unborn children are beneficiaries of the trust. they are beneficiaries and the parent represents their interests. They have a say. And it's a way to not have to give notice to, you don't have to create guardians ad litem and that sort of thing, but the trust, the beneficiaries of the trust are not beneficiaries of the probate. Likewise, the beneficiaries of the second estate are not beneficiaries of the first estate. And
I wasn't disagreeing with you, John.
okay.
I
So
think
I think you eliminate all of this and then just take sub 4 and put that into section 4 somehow and address that. And I think it wouldn't, but I also don't mind making it clear that the trustee acts on behalf of the trust, the PR acts on behalf of that the second probate. My objections are to the conflict of interest standard and also to the concept of representing and binding beneficiaries. That suggests that those people have some right to act on their own, which they don't. So I think this, if you want to clarify that, to say trustee, the trustee is the beneficiary, the trustee acts on behalf of the trust, the PR, the second estate, is the beneficiary, acts on behalf of the second estate, and then go from there.
again, I wasn't disagreeing with you before, John, but let me invite what I think is the other perspective that I think the conflict of interest issue is dealing with, which is, and I think probably Judge Burton and Judge Cobb might be able to talk to this. Again, what I read Section 3 as doing is saying that by default, the personal representative can count on the ability of this list of people to represent and bind people who are interested. But then what if the court is aware that the personal representative of what I'll call probate B, which is, probate B is the probate of a deceased beneficiary of probate A, which is the one that we're administering. What if the court knows that that personal representative is already screwing up? What if the court gets affirmative information that the trustee of the trust that's a beneficiary, the testamentary trust, this estate is screwing up? The personal representative by default can rely on these things, but then the next subsection is invoked when somebody says, wait a minute, we shouldn't rely on the default.
I don't see it as a default. I see it as the reality. The trustee is the beneficiary. It doesn't matter how many beneficiaries of the trustee's trust are suing the trustee. They always have conflicts. I mean, how many, I'm preaching to the choir here, Matt. How many cases, you've had a lot more cases than I have, where families disagree about how a trust ought to be administered. So when that trust is the beneficiary, you don't want you don't want the estate to get bogged down in the disputes inside the trust. And same thing with the probates. You might have a will contest going on in the second probate. You might have all kinds of things going on. You may have actions pending to remove the PR, but you need to get the first estate administered. And all it would be kind of an unusual situation where the resolution of the claim in the first estate somehow prejudiced the resolution of the collateral claims in the second probate.
So this is Judge Burton. I would just offer a couple things. I would like to keep the conflict of interest in first, if we're going to still use Section 3. I think it just is sort of a threshold that says, hey, you can't do this if you have a conflict. Maybe nobody's going to know there's a conflict. Maybe it's going to turn up later, but it's a clear, you can't do this if you're a conflict. I don't necessarily disagree with John that maybe 2 and 3 don't make any sense in this context like they might in the trust statutes. Like Judge Cobb, my sort of biggest concern is what we're doing with minor children, and what we're not addressing at all is who may represent and bind, at least I don't see here, somebody that is financially incapable. I do think that Section 4 does give the court the ability to address if there is a situation where there's not a clear conflict of interest, but the parent, is not in the child's best interest because whatever, they have a criminal record, or I had to remove them as conservator in this other case. I think Section 4 gives the court some ability to deal with that. So that's sort of where I am. But I did have kind of another question, not to derail things, and that's the proposed comment, because I think, in fact, this statute does abrogate making these persons whose rights might be affected parties. It pretty clearly says somebody else can consent on their behalf. So I'm not sure we really want to say, but we're still requiring them to be made parties. Or if we are still requiring them to be made parties, then maybe we don't want to let somebody else bind them.
This is Judge Cobb. To add further to the confusion and mix, is this section specifically for notice? Is that the purpose?
Well, so this is Jennifer, and if you look at Section 4 on page 3, the basic effect of representation, it talks about notice to a person who may represent or bind. It's just like any other notice given to anyone else. And as in an ex parte probate, if you receive notice and you don't object, then that's basically a tacit approval. And then the next section under Section 4, the consent of a person who may represent and bind is binding. So that, and I think, John, earlier you'd asked, wait, how does this all fit in? And I think that is how it fits in, is you're looking at this person who's defined as who may represent and bind, which looks like is either a parent or a guardian ad litem or a special representative or any other person that we agree to keep in. And they have that, so that's the effect that they have in this process.
May I talk really briefly to Judge Burton's comment about the proposed comment? I don't think that there's a conflict between the proposed provision and the proposed comment, because if you're doing a deck action within a probate, you do still have to make everyone parties. But then the question is, if you have a list of 4 parties, one of them being the parent and the other being the 3 children of the parent, the answer is that the parent, absent a conflict and absent the appointment of a special representative, may act on behalf of all 4 named parties. So they do still have to be parties, but the parent may be able to bind the parent may be able to bind the minor children parties.
But generally, you can't have a minor as a party without a guardian ad litem. If in just a regular civil action, you can't just say, I, mom, am filing this lawsuit on behalf of my kid.
In a deck action, the parties whose rights may be affected are usually defendants, and we can and do sue minors all the time.
And you sue minors without having guardian ad litems appointed for them?
Sure. Yeah, the stereotypical way that happens, Judge, is in saying that the people, all of us here on this call, don't handle every day, but which I used to do, which is that the 16-year-old who's driving and T-bones somebody. You sue the minor.
Right. And the minor appears in that lawsuit through their parent?
It's not the job of the plaintiff to get a guardian ad litem. You serve the minor. The minor is a party. Usually the insurer goes and gets a guardian ad litem appointed.
Okay, so there is one. It's not your job as the plaintiff to get that person, but that person does ultimately come in.
Exactly right.
Okay. So you're still, even though you as the plaintiff, it's not your job to find them, that child is still going to be represented in the litigation by a duly appointed guardian ad litem, not just by a parent who says, I'm the parent and that's all I have to be.
Well,
And also, I mean, the court has the ability under section 3 to the court's own motion to say, I hereby determine it's inadequate to have this 12-year-old representing himself in the STEC action. And then the court can say, now we need a guardian ad litem.
Under section 4, you mean?
Let's see, yes, you're right, it got crossed out, section 4, the new section 4.
Right. I'm just leery of suggesting that we can now have parents who have not been appointed as guardian ad litems representing minor children in declaratory judgment actions.
So this is Judge Cobb. Would it address the situation to take out I think it's sub 3, and go down to the next one where it says representation on the motion of any party or the court's own motion, the court may appoint one of the following, and add a parent to one of those?
You're going to appoint somebody as a parent?
No, appoint the representation. I'm down on, I think it's section 4 now. It says representation.
Right.
So may represent.
Well, you can certainly appoint a parent as the guardian ad litem. In fact, that's usually who it is.
Right. So you appoint a parent as, and would that take care of this section that we're all kind of stumbling through?
Well, again, we have, it kind of returns to the initial practicality issue of, you know, I've done straightforward estates where you have a minor beneficiary who has to get notice and there's no conflict of interest and all of that. And so now somebody's having to make a representation to the court that this parent is the appropriate person, and the PR may have no knowledge of who the parent is or who the kid is. And so I don't know if that works, but I also can see the concern of who is the person that identifies a conflict of interest, you know? I mean, it's certainly, I think you could put in the statute something requiring, you know, if anyone becomes aware of a conflict of interest, they need to notify the court of that or something like that. But to give the PR's lawyer, the duty to sort of verify that this person is the appropriate representative, that's out of my comfort level.
But you're also giving this person the authority then to represent and bind a minor child.
So maybe we change this section to, I typed what I'm going to say in the chat. I think our primary concern is notice, and then the place that it gets very difficult is the ability of the person receiving notice to bind. And so maybe we can divide those in some manner that resolves some of the problems, because I'm not sure how we're going to do it, because by virtue of the fact that they get notice and it is treated as a valid and legitimate notice, in some ways that already makes it binding. But what I keep hearing is, you know, most of the time that I'm concerned about having a statutory basis for notices, I've got a child who's not going to get anything, and we're having to notice them pro forma. And we always worry, well, is that notice binding or not? I don't think it is, but then incurring the cost of appointing a GAL for somebody who's not going to get anything is challenging.
So this is Judge Burton. So are you saying that maybe what we would say is you can send notice to these people, and if they get notice and they don't object, that is binding, but they can't affirmatively like consent to the verified statement or stipulate to a settlement, or is that what you're saying?
I'm offering that as an option to solve the dilemma that what we want to have is something that we can rely on so we know that our notice is valid. And then to the extent that there's concerns about the ability to represent and bind, maybe we address that separately.
Because wouldn't there be a good argument if parent received notice for minor child and just sat on their hands and didn't do anything, that the issue would then become between parent and child, not the estate?
You mean at this time or with the proposed legislation?
With your proposal saying a parent can get notice for a child.
I think with this legislation, yeah, then it becomes a problem between the parent and the child. But I think without this legislation, it's a big unknown.
Right. So if it was notice and then we go address represent and bind or whatever the language is down there later on in the statute, I think it would be clearer for attorneys to understand, yes, I can in fact give mom and dad notice. And, you know, if they somehow know and have knowledge of, because, you know, notice under the probate code is basically, you know, you're trying your best to give everybody notice. So if you don't know that dad's incarcerated in Oklahoma, you know, you gave him notice wherever it was, so you did your best.
So it sounds like, and Heather was raising some of what I was wondering is that it seems that part of the struggle we're having has to do about the structure. And I now understand better why this, the section that we're discussing, the new section 3 was originally section 5, because I think part of what gets us concerned is it talks about representing and binding, but we don't know what that's about yet until we get past what is now section 4 and then what's still labeled the second section 4, but I guess would be 5. And so those sections then talk about representation that the court appoints in the what's now section 4, and then the next section is the effective representation. And maybe, as Heather I think was suggesting, there's some way to move the representation by a parent down here, and maybe and that's where it was, of course, because it used to follow this section 4, but make it more specific about what the parent is able to do, because that seems to be part of what's the concern is how much the parent is binding a child if there isn't anything more than the fact that it's just the parent. But it does seem, I now understand better from what Heather and Jennifer have been saying about the need for this to be able to give some clarity to when the PR can give notice and not have to have a jail appointed.
Susan, can I make an observation? This comes from having taken a lot of math classes in school. Judge Cobb mentioned giving notice to mom and dad. The statute says a parent. So there's two parents. Which one or ones get notice?
The reason it says a parent is, John, you know this, sometimes you notice the parent who is the child of the decedent because the parent who is the stepdaughter or former stepdaughter can be problematic.
Mm-hmm. Yeah, no problem.
That's why it says a parent.
But I guess this is Judge Cobb. It raises the question, John's statement raises the question of if it says a parent, can I choose the one who's least problematic?
If you're smart.
That was our goal.
So the mother is the one who is the whose family is receiving the monies, but dad is the one who's less problematic, so you get to pick dad instead of mom?
Well, but then mom would receive notice of that, and she would have the ability on her to file a motion that for whatever reason the representation is inadequate. And so then, she can, then it can become a fight between them. And it's not up to the PR to figure out who it is, they can
But
fight.
she doesn't necessarily get notice if you only have to notice a parent, I think is what Judge Cobb was saying.
Right, but also she had said if mom was one of the children that was going to be getting part of the estate.
Then she's going to get notice the other way.
Right.
Got it.
But then she may not be. She could be written out. It's going to her kid, and the PR would rather deal with the father who's not the blood relative of the decedent. I mean, that it could happen that way.
This is Eric. Do you think it should be clarified that to the extent one parent has a conflict and the other one doesn't, that it's the non-conflicted parent that can sign off?
I mean, that sounds good, but how do you know?
Well, I mean, how do we know if there's a conflict or not? It's just. But if we don't want a conflicted parent to sign off, but I mean, there are definitely situations where one spouse is conflicted or could be conflicted with their child, but the other one isn't.
Mm-hmm.
And I would think we'd want the preference being on the non-conflicted one out.
This is Judge Cobb again. The folks on this committee read the statutes very carefully, and that's not necessarily the case with all practitioners. I think it would be helpful for practitioners to have notice clarified that Jennifer and Heather, that's what you're talking about. It's who gets notice, and having a specific one that's clear for practitioners to see and say, oh, I can in fact send notice to this person, I think would be very helpful for practitioners out there.
So I have a question for Matt. Matt, when you sue a minor, who do you serve?
Well, I haven't had to sue a minor in a while, but back when I did car crashes, you sue the minor. You give notice to him.
And who do you serve?
Process server knocks on the door, says, hey, is little Ginny who T-boned my client here? Little Ginny traipses up, hand her the summons, and the next thing that happens, of course, is at that point you've already been in contact with the insurer, and you say, by the way, I got service on your insured, and they assign defense counsel who then goes ahead and gets a GAL appointed.
So if you're in a probate proceeding and you mail notice to the minor, you've given notice, right? Today?
Yeah, that's right. I mean, that by the same logic, but I mean, here what we're talking about is we're not talking about just sending notice of the pendency of the probate proceeding. I mean, the first section that we're talking about when we're talking about representation is about binding people with respect to a given dispute. I mean, I never counted on, when State Farm is the insurer for little Ginny, it's not little Ginny who's going to consent to the settlement in consultation with the adjuster at State Farm.
Well, I thought we separated notice and acting and binding for the discussion. So just on the notice thing, maybe it's a problem that doesn't really need a solution, because just send the notice to the minor or to the financially incapable person and you've served notice, and whether or not somebody else can act on behalf of that person is a different question, perhaps.
So this is Judge Burton. I think there's a difference between a minor who's old enough to drive a car and, a 3-year-old.
Of course.
Well, so maybe one way of solving the problem is you specify the notice to the parent would go to the parent who is the relative, is related to the decedent, if that parent is alive. And then that way it's clear that, and even if that person is a druggie or, you know, then the other one can, or some other party can say, wait a second, it's inappropriate, we need someone else. But then at least that way it's clear, who does that, which parent gets the notice.
This is Judge Burton. If you're going to specify which parent, I'd be more inclined to say the custodial parent.
Would it be helpful at this point to look at?
Is there always is there always only one custodial parent, or in joint custody are both parents custodial parents?
There can be joint custody. So yes, so that maybe that would make you notice both. But it just seems problematic to me to have a parent making the decisions who's not the parent who has legal custody and is making all the other decisions, like whether they get their ears pierced or what school they go to.
And of course, a minor can be a beneficiary of an estate without having been related to the decedent.
So this is Lorianne, and I'm just going to interject as trying to put all of these ideas down into the draft. And it going back to what Section 3 started out as, am I understanding everybody correctly that we're okay not dealing with subsections 1, 2, and 3, that this is, we're just right now concerned about what happens when there's a minor beneficiary? Am I understanding that correctly?
Oh, this is Judge Burton. Subsection 1 is helpful if you have a beneficiary who's financially incapable, but they have an attorney in fact. That allows the POA to act for them.
I agree.
Okay, so, but then subsections 2 and 3, those are already, I mean, that's pretty much a restatement of current law, right? So is there a purpose for having those 2 subsections in here?
Well, so I thought of one other way where a trustee might become relevant is if you have a financially incapable settlor who has a trustee of a living trust and doesn't have a power of attorney, then that person could be a representative.
I don't think so.
Well,
Because if you've got a person, if you have a financially incapable settlor who is a necessary party, the trustee, unless the claim has been transferred, unless the interest has been transferred to the trustee has no authority over it.
well, also don't, and again, this is assuming people went to good lawyers, but don't most people who are setting up a trust for the purpose of incapacity planning, won't they typically also execute a power of attorney?
Yeah, routinely.
Yeah, but I'm seeing people that do their own trusts and do weird things. But you're right, John. I think you're right. How is that become a trust asset? Although in this statute, you're just saying here are people that have the capacity to represent. You're defining people who have the capacity to represent. The trustee is that trusted person. They know about the person's affairs. But you're right, they don't have any assets they're dealing with.
Right, they have no authority to do this under trust law because their authority is limited to the trust assets. So to make that person, essentially give them a statutory power of attorney is kind of different. It's kind of different.
So this is Lorianne again. So I guess my question was getting at possibly reframing this section 3 to talk about what happens when you have a beneficiary who is incapacitated, either for, as a minor or they're financially incapacitated, and talking about going through the steps of what to do when you have that type of a beneficiary, so that it's very clear for practitioners that are out there that aren't maybe as involved with probate as y'all are. I think this is what, I don't remember if it was Judge Burton or Judge Cobb was getting at, but to kind of provide a roadmap of exactly what to do when you do have a minor beneficiary, or an incapacitated beneficiary. So it would be, you know, to start off with, if you're giving notice, do you have to give notice to the parent? Which parent is it? I'm just listing all this out. I think that these are things that you touched on to make sure that I'm understanding the conversation correctly. So do you give notice to the minor or incapacitated person as well as the parent? And is there an age at which, if you're just giving notice to the parent, is there an age at which you also have to give notice to the minor child, similar to how we do in conservatorship proceedings, where if the kiddo is 14 or older, they also get notice? So these are some, I'm wondering if we can rework this section to do more of what it sounds like you're trying to get at.
Lorianne, it's Heather. I think that's a good idea. Our goal is to make it clear that we can give notice to somebody, and then maybe in a separate section of the statute, the representation, we reorganize it. We make it clear that how a person can bind. I think it's having said that, I recognize the problem with the fact that notice leads to inaction that is the equivalent of binding. But I feel like we need something in our statute to help practitioners. And we've faced all through this committee the problem that we have to draft to the least common denominator.
And does it help if you're reframing that to take what is currently section 8 at the bottom of page 4, which is who must be given notice? Would it help to move that up and kind of put that at the beginning before we get into the representation parts? And that does talk about the person who's 14 or older getting notice, as well as the representative. It just says to another appropriate representative as described in section, referring to the section above, but maybe that could be combined.
I think that makes sense. This is Lorianne. I agree, Susan.
Well, I think Lorianne has maybe started to help us find a way out of this, because I'm looking at it thinking this is really.
So there's still, this is Lorianne again. We still have the issue of, I think what Heather was talking about is having a separate section that talks about when a minor or otherwise incapacitated beneficiary when somebody else can bind them to things. I think we can address that in a separate section, but we do need to talk about what that looks like. What is the trigger for when a parent wouldn't be able to bind a minor child and a GAL would have to, or a special representative would have to come into the picture? And who is it that would make that petition to the court to appoint the GAL or the special representative? I'm thinking of the situation where you've got a personal representative of an estate with minor beneficiaries, and say the decedent and the other parent were divorced, and the surviving parent might have a history of bankruptcies and whatnot. Who has the obligation of notifying the court that that's the situation, and maybe the surviving parent shouldn't be in that position? Is it the personal representative? Is it somebody else? Who's the one that needs to be? How does the court become aware of that type of a situation?
So let's talk about what happens right now. Good lawyers tell the court, I have a minor beneficiary. I have a minor who is an interested person in this estate. And Your Honor, we'd like to A, appoint a guardian ad litem, or B, appoint a conservator at that point. And when we do that, we rely on our personal representative client to give us information that they may have about the minor's parents. And we try to make the best judgment about which parent might be the best guardian ad litem. And if neither parent appears appropriate, then we say, let's appoint the lawyer who serves as a fiduciary, not a different lawyer. The challenge with that is that we are entirely dependent, both the lawyer and the PR, we're entirely dependent on information from others unless the PR has a close relationship within the family. So we can constantly make mistakes. We have no independent way of verifying that mother or father isn't a drug addict. We have no independent way of verifying that they are poor money managers. We are entirely dependent on how it appears, which appearance does not equal actuality. And so that's what currently happens. But here's what I think the majority of lawyers do. And the reason I know that is because I see it. If they have a minor who's an heir or devotee, they don't even bring it to the court's attention, and the court has no way of ever knowing. And the court internal auditing system has no way of knowing. And so they just send it to 5-year-old Mary without ever knowing what happened.
Heather, this is Eric. On the petition for probate, don't you have to list the heirs and devisees and their ages if they're minors? And so doesn't that kind of put the court on notice if they are?
So I think you do now, and that should put the court on notice. But I will tell you that the number of probate petitions that I see without any reference to age is significant. If you think about, you and I might do work like that, but in private practice, I'm curious how many lawyers are seeing that the age of the beneficiary is actually addressed. And a lot of times, Jennifer and I had a case where the beneficiary was 17 and the lawyer just put age of majority on everybody, didn't even check.
Yeah, this is Judge Burton, and it's not uncommon that I have to ask, are any of these beneficiaries minors, because I don't get told.
Yeah, because I think even the forms that are put out indicate that you're supposed to list whether or not they're of majority or not. So.
Yes, well, best practice and reality are not necessarily the same thing.
I can appreciate that. It just seems like whenever we don't have something like that, we always get called. So I just kind of assume most judges will will point that out. So.
And this is Cobb, and I think that when you have larger counties with judges who are specifically assigned to probate, that becomes a matter of course that it gets sent back. When I've been around the state in smaller counties, just listing the names, there's kind of an assumption that those are all the age of majority. And so I don't know that, as I had indicated before, there's a standard of practice of the folks around in this committee, and then there is what the courts see fairly consistently, that it's not disclosed, and it gets sent back and saying you need to amend your petition.
So we've had at least, I'm trying to find when the age requirement, how long the age requirement has been in there. It's 135-035. Excuse me, 113-035. And, you know, we're not going to solve all the problems of probate, but for at least, so the oldest statute I have left in my office in my personal office is 2001. And at least since 2001, you've been required to say whether the heir or devotee is a minor. And I mean, there's just so many cases that I've seen where they don't do that. So maybe when we clean this statute up, we address that head on. You know, and I think part of the problem for lawyers has been is if we do have a minor who's an heir and it is not a devotee, everybody's sensitive to cost. And so maybe we just address this head on. And maybe this statute will fix some of that problem. Of course, that's probably Pollyanna, but that's my hope.
I have a question to ask. Right now, if you need a minor to consent to something, you have to get a guardian ad litem appointed because there's no other option. This would add a special representative option, which would be a simplification. So that's really good. And Section 3 would go a step further and result in the parent being able to act on behalf of the child unless and until a special representative or guardian ad litem was appointed. So to me, it's kind of a question, do we like that, or do we want to err on the side of requiring a special rep to be appointed in all cases? Because until somebody brings it up, the court doesn't know if the representation is going to be adequate. And if it's the default that the parent acts without until somebody chooses to ask for a special rep or guardian ad litem, then the court may never find out. But that's more burdensome because you always have to get a special rep or a guardian ad litem appointed. So I don't really have a strong opinion one way or the other, but to me, I think that's a question that we should answer.
That's a great policy question for the committee. Do we want to have special representatives in probate?
Or actually, I think we all agree we should, but do we want to have the parent be the default until the special rep is appointed, or do we always want to require a special rep to be appointed?
Is there a way of doing it where it's cost efficient in the sense of disclosing the facts as to why you think the parent is in the petition, or why they think the parent sign off on this particular matter should control, and the judge can decide whether or not someone special needs to be appointed or not, or it needs to be looked in further?
So what information would you be providing to the judge for the judge to make a decision whether or not a special representative is required?
I would think you'd say that, the minor beneficiary is 5, the money's going into a UTMA account, the parent is not receiving something because of it, or explaining why it's in the best interest to proceed forward, or why the minor is not raising the claim, and the judge can decide whether or not it makes sense. I mean, you just lay it out, whatever the circumstances are, just kind of tell the story without having to automatically default of having to get someone appointed, because sometimes we're looking at situations where it's a $10,000 bequest. And it just seems like adding an extra even $1,000 and delay of time, it's just not in the best interest of everything. And weighing it out, I'd like to believe that at least 90% of the situations, it is in the best interest of the child. And if there's a way that we could short circuit it, so that way when you lay out the facts, and if the court has more questions, they can ask what's going on, but lay it out enough to where that if it's pretty straightforward, we can just move forward as if it's normal.
So this is Lorianne. I am curious, at what point in the proceeding are you thinking that this would happen, where you lay that out for the court? Because you've got the petition that's filed and you have to provide notice of the petition. So that initial notice, would that still go to the minor beneficiary as well as the parents? And then it'd be subsequent to that you'd ask the court to allow everything else to just go to the parent?
I think the initial, good question. I think the initial stage would stay the same. We'd send it out to the minor and their parent, the custodial parent or custodial parents. But whenever you're looking at closure or getting resolution or sign-offs or releases or trying to do that verified statement, you'd explain why the court should accept the parent signature in light of the minor as opposed to having someone appointed. So I think it's whenever it becomes finalized.
So would it be the personal representative asking the court for that, or would it be the parent of the minor asking the court to allow them to stand in those shoes rather than appointing a special representative or GAL?
I think the most efficient spot would be is that when you're submitting, let's just use the verified statement as an example, that you're submitting the verified statement and enclosed is a sign off on all the beneficiaries. Please note beneficiary A is a minor. Their parents signed on that on A's behalf. And there's an affidavit by the parent outlining why they think it's in the best interest of the child. And then the court can decide whether or not, because then they can look at scope. Is it only $10,000? Is it $2 million? And it can justify putting a little bit more substance into it. But I think having that way, you're kind of putting people on notice. The court's being put on notice. Other people are being put on notice. But we can try to find a way I don't want to use the word shortcut, but having something that's too black and white that requires the extra steps either might encourage people to skirt it because they don't want to spend the money. And I think it's just a way of, again, telling the story and letting it get out there. And if something seems off, the court can ask additional questions.
So you're leaving it, the attorneys don't want to have to go and find out whether the parents are drug addicts or not, but you're leaving it up to the court to make that determination, right?
Well, I think it's, how do you go,
This is Judge Donahue. I think it seems like what we're looking to do is we have the special representative, which can be appointed, which is going to be a bit of a shortcut for a guardian ad litem, as opposed to not going through that expense. I think that the concern has been if we're going to default a parent, make a parent a default person who can bind the minor, what from the court's perspective are we going to be able to look at to make some determination that that's appropriate? Now, as far as there's a couple steps. One is the PR or the person files the original notice and sends that out to the parent, I guess, of the minor child. That's the first step, just to notify them that there's an estate the child may have an interest in. It seems like if we want to streamline this and put it onto the court to some extent to make a determination as to whether a special representative should be appointed, the parent at the point of getting notice would need to step in and do something similar to what a guardian, something similar to what would be required for a guardian, which is to say, I am the parent of this minor child. I've never had a bankruptcy. I've never lost a license. I've never, been convicted of a felony. I want to represent my son or my daughter in this proceeding. Submit that gets on the record. The court then would allow it, and that parent can represent the child during that probate. If they don't do that, then the court appoints a special representative. I think that would give the court the at least as much information as it would need to determine whether a special representative is appointed or not. And then would, I think, at least give, again, it wouldn't require anything from the PR, so there'd be no additional expense to the PR. And if we lay out in the statute very clearly what a parent has to do, I think that would make it probably only as hard as the parent getting an affidavit and sending it to the court.
So Judge Donahue, am I understanding, this is Lorianne again, am I understanding you correctly that you would have the qualifications be similar to, like that disclosure that the parent would send would be similar to what's used for a guardian or a conservator?
Correct, that's something like that. That way the court would have enough information to know whether the person is financially responsible, if they've been convicted of a felony, they've ever been bankrupt, and there would be no, and so just something like that, if we want to put it on the court to make a determination as to whether a special representative should be appointed. I don't think what we're trying to do here is just default someone the court's never met and knows nothing about to bind a minor child. And I don't think that really we can do that. And if we want to take the work off the personal representative to do the investigation, then there has to be some information provided by that parent to the court to allow the court to make an informed judgment as to whether a special representative needs to be appointed.
Could there almost be a template that we could send out? So when we know that there's a minor that's an interested person, we can almost send out that template with that first notice?
I wouldn't see why not. I mean, it seems like it's a pretty standard template. We have them for guardianships and conservatorships. Just again, if we're looking, because it sounds like what I've been listening to this conversation, we don't want to put any onus on the personal representative. We want to make this as cost effective as possible. We want to give eligible parents the opportunity to represent their children, and we want the court to make a determination as to whether they can do that. And really, that's I don't see how that's going to happen without the parent having some duty to step in and ask the court, hey, I want to represent my child and here's why I should.
Seems reasonable.
I think that's a good idea. And I think it's good if you can allow that to happen at any place in the process, because conceivably that could be filed at the same time that the petition is. And I think it's also good if you don't make allow some flexibility in case there needs to be an explanation about something in the background. Yeah, I had a bankruptcy 25 years ago. I've been gainfully employed for blah, blah, blah. I mean, so you can explain away some of the weird things that happen like you do in a guardianship petition. So I really like that idea.
This is Judge Burton. I like it too.
This is great. Thank you, Judge Donahue. That may have solved part of this problem, although it creates more issues for Lori Ann.
Nah, that's fine.
I apologize, Lori Ann.
That's perfectly okay. So one more question that I have is, what's the upper limit of the parental authority? So does once the kiddo is going to be inheriting more than $10,000, then you do have to have something more than just the parent?
There's a statute that controls that.
I should know that.
It's does anybody know this? Whitman, somebody knows statute right off the top of their head. It says it in the statute. It's I'll find it. I still have a book because I don't always know where to look on the computer. I think it's under 126, but I'm not positive.
It's 126, 730, I believe. But that, I don't know that clearly connects to the probate statutes. It talks about payment in amount not exceeding 25,000, maybe paid to a person having legal custody of the minor. And I'm not sure courts can even want that. That again, you don't want 25,000 to go to.
Yeah, but they can now, Jennifer.
But through a probate?
Well, they can do it in, like, if the minor's entitled to a judgment, like a car accident. 25,000 is 25,000 regardless of the source of the money.
Well, I agree, except in a probate court, the judge has to authorize it.
Well, I think there's another separate statute that says the PR can give, and I think it's up to 30,000 to sort of whoever they want without court approval. I seem to remember seeing that somewhere, although off the top of my head I can't tell you where.
Are there limits if it says paid to the if it says paid to the custodian to be held under the Uniform Transfer to Minors Act? Is there a cap on that?
Yes, there is. That's under ORS 126.822 sub 3C, and that's what Judge Burton was talking about. The transfer can be made if the PR considers it to be the best interest of the minor, and if it exceeds 30,000, it has to be authorized by the court. But the way that I would see this is you would have to say in your petition for distribution, you want, the 25,000 to be paid to mom as custodian for Johnny. And all the judge would have to say is, no, I don't like the idea of that, even though the statute authorizes it. I think because the judge is the one who gets to sign the final distribution.
So I think that In a lot of places, people honor the terms of 126.730, and it says, when a person owes a duty to pay a minor under the terms of a judgment, which would be a general judgment of distribution, they may pay it to the parent. And I've seen that used. So you get to choose 25 or 30. When it's 30, you have to put it in a UTMA account.
And how is that different if we say pay it to the parent to be held in trust for the benefit of the child until the child's age 25 or age 30? I mean, there's no limit on that threshold, on that provision, correct?
In 126.730, you get to give it to the parent or a person having legal custody of the minor. And then if they're represented by an attorney, there's rules. If they're not represented by attorney and the judgment is paid in cash, it goes directly into an FDIC insured account in the sole name of the minor.
Right, but going with John's comment earlier, you know, the trustee is the beneficiary. If it says pay to mom as trustee for the benefit of child under the terms of this trust, and even if the trust just says payable at age 30, and that's all it is, you've created a trust, and theoretically you've kind of worked around the UTMA limitations of whether it's 25 or 30,000. I'm assuming there you'd still have the trustee sign off on it, and the kid happens to be the beneficiary of said trust.
Well, the example that I understood we were talking about was where there wasn't a trust and like created in a will. So we're just having a dollar sum of money that's payable to a minor. And then in that case, we can either use 126.730 if it's under 25,000, or we can use 126.822 for the UTMA. And the court has to approve that transfer if it exceeds 30,000.
Correct, and I was stepping one step forward, just in the sense of how is it really different naming parent as trustee of some trust as opposed to giving parent as custodian under an UTMA. And I went too far academically speaking. Sorry about that. You're correct. What we were looking at.
I just I don't think that I had ever noticed the potential conflict between those two sections, and the person who knows everything about this is Brooks, who's not on the line. And so I've flagged that for him. He's been involved in previous revisions of the UTMA. So I'll flag that for him. So maybe at our next meeting or between now and then, he can tell us whether we're actually reading it wrong.
I think that they're intended to be different because one of them creates a bank account for the minor and one of them creates a UTMA account. When you have a UTMA account, somebody has access to it and can do things with it. And that's not necessarily true with that savings account set up for the, you know, the 25,000 direct to the minor versus the 30,000 to the custodian, where there's nobody who has authority to transact on that account, is my understanding. But I'd love to know what Brooks knows.
So this is Lorianne again. So as far as what we were talking about, setting up a separate section that just talks about when you have a minor who is an interested person in the estate, for kind of a roadmap of what practitioners need to go through. We've got that the initial petition, the notice can go to, I'm still not clear. Do you want the notice to go to both the minor and a parent for the minor at this point for the petition?
This is Judge. Could we follow the Chapter 125 notice and say when there are more than 14, they get notice as well?
Yeah, we can do that. That makes sense. And then, so you send the petition out to the minor if they're over 14 and the parent for the minor, whichever parent that might be. And then it's up to the parent to submit something to the court requesting the court to allow them to represent their minor child instead of appointing a special representative or a GAL. And then the question I still have, and we got kind of off track talking about distributions under 126, is what is the limit to what the parent, where's the limit for what the parent can do? When is it that that parent's no longer able to stand in those shoes and you do need to have the court to appoint a GAL or a special representative? So can the parent just throughout the entire process, you know, receive notice of, say, an interim accounting or the inventory and any, you know, petition for instructions, those types of things? Or is that, is there a point at which that should be a GAL or a special representative? And what are those triggers?
Judge Donohue.
I'm not, the
Go ahead.
triggers
No,
are
go ahead, Judge Cobb.
sorry, one of my suggestions is when the parent is petitioning the court, they need to tell the court what they, you know, if it's just initial, I don't know, notice as opposed to some kind of complex litigation, as opposed to signing off on a verified statement. It seems that in the court's decision about what to appoint the parent or what to allow the parent to do, the parent has to provide that information so that I know how far I'm going to go with this person.
So Judge Cobb, would you be comfortable with the parent would submit something asking the court for permission to stand in those shoes, and then the court would sign something that says, this is what the parent's allowed to do? And then that would be a limit on it. At least that way there's something that they've got on hand that says that, oh yeah, I'm still allowed to do this, but not these other things. We have to do something different.
At this point, I think it would be, because at the very beginning of an estate, I don't know which direction it's going to go, or whether there's going to be a will contest. You know, you really don't know. So for me to give a parent carte blanche, I'd be a little concerned about that.
Well, and I think this is Judge Donohue. I think the other thing too is there's always the backstop of a special representative later on. If the parent, you know, if it does get to be a complex, if it gets to be a complex will or complex estate, the parent comes in initially at the notice stage, moves along, and it appears that, you know, this parent, they're out of their depth. They're not filing responses. They're not adequately addressing something that an attorney is raising on behalf and you know, representing the child's interest. I think under subsection 4, the court at any point could step in and say, okay, parent of child, you're in over your head. I'm seeing what looks to me to be some concerns regarding your ability to represent the child given the complexity of the estate, so I'm going to appoint a special representative. So I think the court always has that ability. I don't think that if we gave them, you know, I don't think we would give them carte blanche that's an irrevocable designation for the entire pendency of the estate.
But Matt, if they're signing off on things, how do I know how far things have gone and when they're out of their depth? Because you know as well as I do, the court's the last one to know.
No, I agree. I'm just saying, I'm saying, you know, I'm not saying we shouldn't have something at the outset that establishes outer boundaries. I'm just saying that even if we, you know, even if we do that, there's a backstop that the court has of appointing a special representative. So it's not an irrevocable, I'm just saying it's not an irrevocable designation at the head of the parents, of the head of the estate proceeding of the parent's authority that the court can't address later on.
Oh, I see. Thanks.
I think it would be helpful if we had a title for this role. We've got special representative, we've got guardian ad litem, and then and if it could be possible that appointment could be requested in another document. So say for example, there's a motion to approve a settlement agreement, and then, you know, you add to that motion, we request the parent be able to sign on behalf of the minor, and attached is the parent's declaration that complies with the, you know, whatever. I think we sort of need a little clearer process.
So this is Anne. I think we're running out of time. So we have about 10 minutes left. And what might be helpful is if I take a shot at drafting this new section that talks about, you know, putting out this roadmap for when you have a minor or otherwise incapacitated beneficiary. And then maybe Sandy can circulate that, or I can work with a couple of people, a smaller group, to dial that in, and then Sandy can circulate that to the wider group for discussion at the next meeting.
Yeah, definitely happy to help.
Who should I work with on that? Would that be Jennifer and Heather, or are there, I mean, Brooks, I think that Matt had mentioned that Brooks might be a good one to work with. Who should I, smaller group, to circulate this to?
I'm happy.
Lori Ann, this is Judge Cobb. Since I'm the one who's had the burr under my saddle, maybe I should be in it.
Okay.
And it's Jennifer, and I'm happy to be involved.
That sounds like Jennifer, Heather, Matt, Brooks, and Judge Cobb.
I'm gonna try to do my best to be helpful, but I'm preparing to move houses and we have all this other stuff going on. So I apologize in advance if my availability is limited.
Good to know. Well, and thank you, Lori Ann. I think your guidance has helped frame this discussion and get us back on track a little bit. Looking farther into the chapter 111, it looks like there are still a few more things that we need to talk about once we get this, the parent issue dealt with. There are some questions that you had in connection with the appointment of the special representative that we can get to, but I think figuring out this parent piece of it's going to be pretty critical to make this work. So thank you, and thanks everybody for being able to help us puzzle through all of these issues. I think Sandy and I were hoping we would get it all done today somehow.
Yeah, thank you, everyone. I think we're definitely gonna have another meeting on chapter 111 at least, and but that's very par for the course for this group, and I really do appreciate all the help. Lorianne, if you need the contact information for the folks who are going to be involved in this, your work, just let me know, and I'll send those to you. For everyone else, I'll send out a scheduling link. We're doing about every 2 weeks. I'll put out some options in the next couple of days, and we'll get another meeting scheduled.
And the one other thing I wanted to say is part of the reason I was hoping we would wrap this up today is that I'm, of course, eager to get onto electronic wills where I do know something, in contrast with today where it's, wow. So we will get to that eventually, probably not at the next meeting, but I did want to let you know, and thanks to John Dranius for pointing this out to me because I hadn't seen it yet. The ACTEC website has a podcast about electronic wills, about the Uniform Act. The podcast was done by Susie Walsh, who is the chair of the Electronic Wills Drafting Committee, and Attorney Berry, who was and is the vice chair of that committee. And it's only 11 minutes long, definitely worth a listen. It's a kind of good explanation of where things are around that. So I sent Sandy a link to that to send out when you get a chance. Take a look, or just set it aside until we get back to electronic wills. The ACTEC homepage has, I'm sending a link, but on the homepage there is a link to podcasts, and it's on the public side of the website, and there are a whole bunch of podcasts about all sorts of topics connected with estate planning, broadly defined, and they're all pretty short, so you might be interested just in general now that some of us have at least a little extra time because we can't do some of the things that we're supposed to be doing. And eventually we will get to electronic wills, but not at the next meeting, I think.
Thanks, Susan. And I'll send the link to the podcast out with the scheduling link in the next couple of days.
Oh, great. Anything else for the good of the order?
Susan,
Can I just recap what I think we have been discussing? Make sure that I understand where we are.
Yeah, thanks.
The idea was that we're going to have some sort of uh, less formal, some certification given by a parent that would explain why the parent is capable of acting on behalf of the child. And that would be kind of like a special representative light. And at any point in the proceeding, the court on its own motion or an interested party or something can say, hey, this is over this person's head. We need a real special representative or guardian.
That's what I was hearing. Does that, Lorianne, does that sound right?
Yes, but I think somebody said right at the end of the conversation that maybe when you've got folks have to sign off on something, like for example, I can't think of something right now that would work. Maybe a verified statement, maybe not. That there would have to be at that time something submitted by the parent as well, saying that this is why the parent should be able to sign on the behalf of the child on this particular document. So that first thing, allowing the parent to receive notice of the documents, might not be sufficient for further bigger things that the parent might be consenting to or binding the child to. Am I hearing that correctly?
That may be right, although part of what I thought I heard was that was a little different, and it was that even if the parent didn't kind of make the certification or the whatever we're calling it initially, they could come in later and say, at this point, I want to let you know, court, why I am able to sign off for the child. So it could be something that could be done initially, but also could be done for the first time later, I think.
Right, but the initial one might not work for a later one, depending on what that is. So it's not just carte blanche for the rest of the probate proceeding.
Right, and that was one of the concerns I heard, I think, from Judge Cobb, that carte blanche is somewhat problematic. Although what it would look like, because things might be sufficiently straightforward that it would be okay.
Mm-hmm. Yeah, so I'll take a stab at drafting this, and it's going to be, it's going to be a rough draft. It's going to have some policy calls that I have to make. I'll point those out so that the group can assess the policy calls and decide if that's what the group wants. And having the smaller group look at it first, I think will be really helpful to make sure that we use our time effectively in the next meeting.
Great. Well, thanks everybody. Thanks for staying with it on this one where it feels a little mushy, but I think we have made progress, and we'll be able to be a little more clear with Lorianne's good help and also the help of those of you who will be helping guide us. It is important, and one of the things I've learned over the course of today's discussion is the need for something like this. I didn't really quite understand why it was necessary, and I do understand that now, so I'm glad we're working on it. Thanks. It's cloudy here in Eugene, so maybe there'll be better weather tomorrow. Enjoy the sun if it ever comes. And we'll see you shortly after Sandy tells us when.
Thank you all. Appreciate it.